So difference, as you know, the Warsaw Court is currently hearing the extradition case of the Russian archaeologists who for many years conducted the research in the Ukrainian Crimea, and he continued his research after Crimea was occupied and later annexed by Russian Federation. This person was detained. He was arrested in Poland, and currently, as I said, the Warsaw Court is here on the extradition case, which we wrote about a couple of times last week. And we decided that why not invite prominent scholars to discuss this topic, probably not only about this specific case, but like to look at this issue more broadly and to look at the occupation of the Ukrainian culture and the legal implications of that. So, Professor Roger O'Keefe is the author of, I guess, 1,000 or maybe a little bit even more articles on the topic, and so I'm really happy that you, Professor O'Keefe, agreed to have an interview with us today. So thank you and welcome to the Dead Lawyer Society. And my co-host today is Yulia Shaipova, our active member of the DLS community of our chat. Yulia is the legal and policy professional and recent graduate of Oxford University. Yulia, Mr. O'Keefe, happy that you're here. And so let's begin.
Yes, thank you so much for the introduction, Dima. And probably let's start with a very broad and general question of whether occupation can be granting any legal right to conduct archaeological excavation to the occupying power, or is the default international law position is that such work is unlawful unless it's kind of exceptionally justified?
Okay, first thing I should say, Dima and Yulia, is that for the people there at home, first we have to distinguish, of course, between international law and national law, and sometimes the two meet in the area of occupation. We also have to distinguish between what the occupying power as the state itself may or must do, and what any individuals may or may not be able to do. Now, the final thing is, of course, we have international law under certain treaties, and then we have the more generally applicable international law to all states, so-called customary international law. Now, we do have one treaty in which archaeological excavations in occupied territory is actually dealt with. Ukraine itself is a party to this treaty, but the Russian Federation is not. To go back to the beginning, in 1954, there was a convention, and there still remains a convention on the protection of cultural property in armed conflict. And in that convention, there is no rule specifically about archaeological excavation. It was raised during the drafting, but in the end, such a provision was left out of the treaty. In 1999, they added to the treaty what is called the protocol, that is the additional treaty, the second protocol, to which, as I said, Ukraine is party, the Russian Federation is not. But let's say we have a situation in which both states are party to the convention. Well, there is a rule in the convention which says that the occupying power must prohibit, prevent, and put a stop to all archaeological excavations. So they must basically stop them, stop others from doing them, and then naturally themselves may not conduct them. But if we're talking about the general law in force, then the situation is this. So if we think of what is occupation, occupation as conceived by the laws of war is a holding pattern. Okay, so the idea is that the occupant comes in, the occupant does not have right to the territory, it's not there's no such thing as conquest in international law anymore. The idea is that the occupant must leave everything as it is, okay? And basically just run the place for the benefit of the local population until a peace treaty is signed, okay? And what this means is that the occupying power must itself leave in place the existing law and must abide by the existing law. So Ukraine's got a law on archaeological excavations. Russia comes in. Under the law of occupation, it's not allowed to touch that law. It has to leave it in place. And it has to abide by it. Okay, so it has to follow the law applicable in Ukraine to excavations in Crimea. And so any individual who then engages in archaeological excavations would simply still be bound by the Ukrainian law. Even if Russia changes the law, it's not permitted to do so. And so this is our situation then of the archaeologists we're talking about here. Presumably then Russia comes in, changes the law, doesn't change anything as far as international law is concerned. Ukraine, I presume, revoked the permit of this archaeologist. And so he gets caught by Ukrainian law, okay? Not by international law, by Ukrainian law. Russia itself would be responsible for changing the law, and itself would be responsible if it took into its hands the authorization of archaeological excavations. So you have Russia's responsibility, and in terms of our archaeologist, he remains bound by Ukrainian law, and therefore he can be caught under Ukrainian law, which leads to then the idea that he's arrested in foreign territory and extradition is requested in relation to him. All of this, by the way, is separate from the idea that you can't steal stuff in occupied territory, you can't destroy stuff in occupied territory. That should all be taken as understood. I take it you're just talking here about, whether you can actually dig for things. I'm happy to talk about the rest, of course, as well. So the answer to your question is basically, depends what the local law says. If the local law outlaws it without permission, then the individual will be caught by the local law rather than by international law, but is caught by the local law because international law says that the local law stays in force, if that makes sense.
It does. But is there any meaningful difference between the passive damages to the cultural heritage and deliberate archaeological excavation carried out on the occupied territories?
Yes, if you do you mean deliberately damaging the cultural heritage?
Yeah.
Yeah, sure. There is a big difference, exactly. So the occupying power is absolutely prohibited from destroying archaeological material or any cultural heritage, and individuals themselves are then directly prohibited by international law from doing so. And so, we can talk about this later, will themselves be responsible for a war crime. Okay, they will have committed a war crime if intentionally they destroy cultural heritage in the occupied territory. So you can have a situation in which both the individual and the state will be caught by international law. The same goes if they misappropriate, in other words, to steal the cultural property. Both destruction and the theft will be a war crime for the individual and a violation by the state itself. So destruction and theft are the easy cases. Simply digging material is the more complicated case.
But is stealing? Yeah, I'm sorry. You just the additional question: is stealing really provable? How can I know that they steal anything if I have no idea what they found during the excavations?
Sure. I mean, well, yes, it is a problem. I mean, that's not a problem of the law as as such, but of its enforcement. And yes, that makes it extremely difficult if they don't declare, they just carry it off. Then, of course, it's very difficult to know what's gone on. Very difficult to prove the theft, and this is the same with any theft, really. I mean, if the thief wants to, they can cover their tracks. Now, the way to get around that, I guess, is the sorts of things that we've seen in relation to other forms of war crime in Crimea. What are they called? Truth hounds and various organizations like that, which involve local people secretly documenting these things themselves through photos or whatever. Extremely courageous people, it has to be said. So there's that. If it's done on a wide scale, there is available these days a lot of satellite imagery, both through the United Nations and through various private organizations. And it's amazing what they can do. There's an organization called Forensic Architecture, for example, and they have access to open source material, and they can actually see where stuff has been stolen from. So in Syria, for example, amazing satellite footage. Now, that doesn't necessarily prove exactly who stole the thing, but if we're dealing in an area with something in which the only people in that area, representatives of the occupying power, well, then it stands to reason that they were the ones who stole it. So yes, it's extremely difficult to know, but these days it's getting a bit harder to deny what's gone on.
Now, what can we say about negative and positive obligations of the occupying power? So one thing is not to touch anything, not to destroy anything, not to change anything, but whether there are any active action that the occupying power has to do with regards to cultural heritage of the occupied territory.
Yep, absolutely. There are positive obligations. So when it comes to vandalism and theft of cultural heritage, okay, sure, the occupying power can't do it itself, but it also has an obligation to prevent others from doing it. So that it has to do everything, within its power, reasonably within its power, to prevent and put a stop to these things. I mean, one thing it has to do is to make it clear, through, if necessary, through additional military law, to say that these things are not permitted. But they have to put guards on, various sites. Now, that doesn't necessarily mean they put soldiers on the sites, but they have to get security and so on, and positively protect the cultural heritage. So the famous example for when the Americans went into Baghdad and they failed to secure the Iraqi National Museum, they themselves didn't steal anything, but they violated their obligation to protect the museum. And so that's exactly the situation you would have in Crimea, so that the Russian Federation would itself not be able to steal stuff or destroy stuff, but also would have an obligation to ensure that others don't do so. Similarly, an obligation to make sure that they don't unlawfully export anything out of the territory. In terms of other positive obligations, they have a positive obligation to cooperate with the local authorities insofar as they're still there, to protect the cultural property. The problem is that presumably they've got rid of the local authorities, but nonetheless, in those situations where they do remain, they have to help them protecting the cultural heritage. Clearly, in a situation in which, like in Crimea, the power just comes in and gets rid of everyone. It makes it difficult, but they still nonetheless have violated the law, and then later that might come back and they'll be held responsible.
Yeah, you also started talking about like responsibility, personal responsibility of a state, but also of personal responsibility and responsibility of the state. So how can we attribute that conduct to a state? Because, for example, in this case, can Russian authorities claim that he was doing this in personal capacity and hence the state is not responsible for what was done? Or considering the active involvement of Russian officials in this whole case, in general, it can help for the attribution of the state to the state?
Yeah. So, I mean, just the background for your listeners here or your viewers, only those acts which can be considered the acts of the state, will lead to the state's own responsibility. Now, usually this means that the state's own officials, maybe it's got its own archaeological teams or something like that, their acts will become the acts of the occupying power, in this case, the Russian Federation. But you can also have situations in which an individual's acts, if they're under the direction and control of the state or under the instructions of the state, will become the state's conduct. So let's take an ostensibly private archaeologist. If actually that archaeologist is operating on the instructions of the state, their acts will become the act of the state. Now, it's much more difficult when the state simply doesn't stop them from doing it. So the state will itself breach its positive obligation to stop them, but the acts of the individual will not themselves become the acts of the state, okay? You will always, however, have the situation that the individual's own acts are the individual's own acts, and in this case will be caught by Ukrainian law if it's just a matter of digs. And of course, if they steal anything or destroy anything, will be caught also by international law. But yes, I mean, we have rules about attribution, and then the question is simply proving them on the facts. In other words, was it the case that this person actually was working on the instructions of or under the direction of the occupying power? And as with all things, it's simply a question of proof then, and it may not be easy, but it's nonetheless legally possible, sure.
So in this particular case, we can see that the Russian authorities will be invoking the arguments of scientific research and cultural preservation, that actually they will be contributing to something good. So would this be a valid arguments for such a case? Okay,
well, the scientific thing, the idea that, this is helping people, no. Were they to say that the point of the excavations was to stop other people stealing the material which had been unearthed, technically, of course, were that true, then that would be an example of an act to prevent people from stealing, and that would be perfectly okay. But of course, the problem is, is that actually the case? And if they just use that as a pretext, well, then international law says, well, that's bad faith, that doesn't count. But just the basic idea that, oh, well, we dig stuff up, it's good for human knowledge. No, that doesn't permit them to do that.
This is actually a very good point about prevention of looting and, for example, preservation of cultural heritage, because I think they invoke this in other cases in Crimea. The cultural heritage is getting, destroyed for the sake of time, and we need to do some works to help preserve it. But what would be the Ukrainian arguments in this case to show that they fail the necessity and proportionality test and that they still violate the rules on cultural heritage preservation under the occupying power?
Well, I mean, necessity and proportionality doesn't come into this. That's more about when you're bombing something. Or you would have, the Ukrainians would say, well, no, this wasn't really about preventing. And then it comes down to an argument as to, they say, we say. But look, the international courts are used to this sort of thing. So just because, for example, Russia could say that doesn't mean it's going to be a winning argument. If it's clearly an abusive argument, it's just exploiting the law, then as far as international law is concerned, that's no good. and the Ukrainian argument would have to win as far as international law is concerned. And so it's just a matter of proof of the motives, and then there's various ways then of establishing the motives. If, for example, that stuff gets taken back to Russia, gets put on display in a museum or something like that, gets nationalized under Russian law, well, then it's clearly not just to protect the heritage. If, on the other hand, it was taken to a safe place, preferably within the occupied territory, was looked after properly and so on, then the argument would be much easier to make that it was to protect it. But usually in these situations, it's pretty clear from what later happens to the material which one it is. And generally it tends to be that it's really just theft, no matter what argument they make.
So do I hear you correctly that you say that basically the removal of artifacts significantly contributes to the assessment of the gravity of the violation under the Hague Convention?
Well, not just the gravity, whether in fact it is a violation. So, if the Russians say, oh no, we're protecting it, and the Ukrainians say, no, you're not, you're stealing it, then if afterwards it shows, it's clear that, no, it's not about protecting, they take it home, they put it in a museum, they display it to everyone, and most importantly, they refuse to give it back, then it's clear. And then, of course, yes, that would make it more serious, but the more important point is that it actually proves in the very first place that we're talking about theft and not about protection.
Would it
the other
help
thing
to
about protection too, sorry to interrupt, other things which would help show it's about protection would be, for example, if Russia got in touch with UNESCO or got in touch with the International Council of Monuments and Sites and said, listen, we've got this issue here. In good faith, we're trying to protect the heritage. Let's cooperate. That would be an excellent indication that, in fact, it is about protecting. So calling in international partners would be the best evidence. And then on the other hand, Ukraine can say, listen, if you were really about protecting, surely you would have contacted, blah, 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 UNESCO, ICOMOS, ICOM, the International Association of Archaeologists, or something like that. You've done none of that. So that would help prove in a circumstantial way.
I was also thinking about the possibility to prove the systemic nature of such perpetrations, to say that it's not only, one-off event of cultural preservation of this particular cultural site, but it's a general systemic state policy. Would it work in your experience?
Yeah, exactly. If you can show that it fits into a pattern of, identical or very, very similar things, then yes, it makes it much easier to prove. It also probably aggravates the damage, the harm, and so would were in the end there to be some international claim about it, make the international wrong by Russia all the worse. But yes, in terms of establishing things, if you can show, listen, in all the other cases, this is what's happened, then, on the balance of probabilities, it's pretty obvious this is the same sort of case. So yeah, the systemic nature absolutely can, very sadly, can help establish the case. Of course, the last thing you want is a systemic situation, but if there is one, then yes, it helps.
Does the valuation make any sense? Because the defense of the archaeologist challenges the valuation of the items that were expropriated. So does it really make sense if the cost of the items is not 3 million, but it is 1 million, or maybe even like 100,000.
Doesn't change anything. I mean, look, if what it may change is if a civil claim comes and the question is how much, the person or the state has to compensate, but it doesn't change the actual offence. I mean, it could be worth nothing really, but it's still, the unlawful digging up of cultural heritage. So yeah, it's no good to say, oh look, it's worth $5. Who cares? Well, no, the law is the law, whatever much it costs. And of course, as you, well, both of you, but Yulia in particular was mentioning, of course, the real loss goes way beyond the monetary value of the thing. The real loss is to the cultural identity, the cultural life, the cultural self-knowledge of Ukraine, but also, of course, of the wider world, of humanity. Humanity loses diversity, humanity loses something which in some metaphysical sense belongs to everyone, even if in a legal sense it belongs to Ukraine. All the international treaties say this, that loss of the cultural heritage of any state is loss to the cultural heritage of everyone. So that's, in the end, a good answer is that, look, even if it's worth nothing in monetary terms, it's still a loss. And so the monetary value is immaterial to that extent.
It's very interesting that you mentioned that it, in a broader sense, it belongs to the world. Mm-hmm. Does it create in this case, can it create in this case, erga omnes obligation for other states to act in protection of certain cultural heritage items on behalf of the state whose territory is occupied?
That's a fantastic question. So, I mean, for the benefit of your viewers, I mean, what this would mean is that not only Ukraine could bring a claim against Russia, but that any other state could bring a claim against Russia. And the short answer to your question is yes, it definitely could. It would be exceptionally easy under one of the relevant treaties to show that this is an obligation owed to all the other treaty parties. And the way you show this is that in the preamble, the bits at the beginning of the treaty, it actually talks about the cultural heritage of humanity, of all the states, parties, and so on. But I think also more generally under customary international law, given that we have all these statements in all the laws everywhere, about this metaphysical value to all states, I don't think it would be difficult at all to say that these obligations are owed to all humanity, to the so-called international community as a whole, as the law says, and so that not just Ukraine, but whichever state could bring a claim against Russia, of course, not for itself, okay, but to insist that Russia return the material to Ukraine or compensate Ukraine. And so, yeah, absolutely. It's an excellent question. And I would like to see that sort of action taken. It would be a fantastic landmark in legal terms.
So we already started to talk a little bit about private criminal responsibility of an individual and the broader attribution to the state. So do we understand correctly that they coexist? And so criminal law is equally applicable and extradition is a perfectly applicable tool in this case, along with state responsibility.
Exactly. Well, in fact, when it comes to the individual, there's potentially two levels of responsibility. But yes, so on the one hand, you've got the state. And then when it comes to the individual, if the individual, for example, steals something from occupied territory or destroys it, then you have international law, which criminalizes that as a war crime. But if it's just simply digging up the material contrary to Ukrainian law, and if that's a crime under Ukrainian law, then yeah, quite separately from what international law says about the state, Ukrainian law is still applicable, and the individual can be criminally responsible under Ukrainian law. And this, from what I understand, is precisely the situation we're talking about here. So yeah, even under international law, the responsibility of the individual and the responsibility of the state remain separate, even when the individual is working for the state. So let's talk about, let's say it was a state-employed archaeologist. Their actions are the actions of the state, but they themselves will be bound by certain laws of international law, not to steal the stuff and so on. So you can have a situation in which, even under international law, both are responsible, but you can also have a situation like our archaeologist, in which Russia might be responsible under international law, and the archaeologist, for conducting an unlawful dig, will be responsible under Ukrainian law, and they can live happily together.
So there
Which
seems to be
extradition. Then leads to the question of extradition, because just like anything else, you know, if you commit any other crime under Ukrainian law, and you know you turn up in Poland and Ukraine requests Poland to arrest the person, then this is how extradition comes into it.
Yes, I wanted to say that there seems to be quite a large body of legal norms, both like local domestic ones and international governing that, and quite a number of academic publications on the topic. But what do we know about precedents in this area? Has anyone ever been charged with similar war crimes? Has anyone been put on trial for this? And what has been the ultimate outcome of these proceedings?
Okay, well, when it comes to destruction and theft, the answer is absolutely. So let's focus on destruction. It's a little known fact, but in the great trial at Nuremberg, at the end of the Second World War, 3 of the defendants, in fact, no, I think 5, amongst their other crimes, were charged with their responsibility for the massive plunder of the cultural heritage of, in this case, the former Soviet Union, and were convicted of that. So a man called Rosenberg, who was in charge of a group, an Einsatzstab, who went around and actually stole the material, he, as well as Ribbentrop and a couple of others who were sponsoring such things, ended up being convicted of war crimes in that regard. In terms of the destruction, same thing too. And then the destruction we saw lots of in the former Yugoslavia. So many of the people who were convicted of other crimes in the former Yugoslavia were also convicted of the destruction of mosques across Bosnia. 2 of them were convicted in relation to the bombardment of Dubrovnik. Some of them in relation to acts against cultural sites in Kosovo, and so on. And then most recently, a man called Al-Mahdi in the International Criminal Court, he pleaded guilty to the destruction of 9 World Heritage listed mausolea in Timbuktu. Now this guy, a bit like all the modern ones these days, he was a Islamic fundamentalist affiliated with the Islamic State. They videoed these things. So he's there going, as they're destroying these sites, so he could hardly say that he didn't do it, and he was convicted. So yeah, when it comes to destruction, we've got lots of precedents, if you want to call them that, and with theft, we've got a few as well. Now, I've got to be careful about the word precedent in international law. Strictly speaking, it doesn't exist, but effectively they are precedents. In terms of at the domestic level and extradition, in terms of simply digging up something, this is the first case I've ever heard of. In terms of destruction, there is a really slightly crazy case going on at the moment of a Japanese guy who I think he's very opposed to Shintoism or some crazy thing, he has in his head. And he destroyed something on a Japanese shrine not too long ago. And he's been arrested in a third state and he's going to be extradited back to Japan. I mean, that sounds like a crazy example, but he's violated Japanese law involving the destruction of cultural heritage. And so it's not too different from the case we have here. So yeah, the answer is it may come as a surprise to people, but there is quite a lot of case law in this regard.
I want to ask about if any consensus exists between the international law experts and international law scientists on this particular topic. But before that, I think there's another layer of this problem is the ethics. And when I was reading what the Russian archaeologists say about what happened with this Hermitage guy, some of them said that it wasn't only unlawful, but it was unethical to do that. Mm-hmm. What do you think about this? And my second question is, what other scientists, what other scholars think about that? And what I found, it was, first of all, not that many papers on the topic of international law and cultural heritage. And those papers that exist, I guess all of them are saying that it is unlawful and unethical. But since it is you who's the scholar, not me, is there any opposition to this idea on the lawfulness and unethicalness of this?
I mean, I guess that the question is what you mean by unethical. I mean, there's formally unethical in the sense that it violates codes, internal codes enacted by the international society.
I probably mean the perception. So
the perception, sure.
The perception and the default feeling about that. So
yeah,
default feeling. When the normal average scientist, scholar look at this problem, it usually thinks, well, come on, it's obvious. It's obviously unlawful.
Sure.
Is it the case?
Well, in this case, because it's a complicated case, I mean, there may be archaeologists out there who think, well, I don't know, it doesn't seem obviously unlawful. Now, I think most archaeologists would say, listen, I mean, you're pretty silly to get involved in that because there is a gut feeling that if you're digging simply because the occupying power has permitted you to continue to dig, then that kind of smells. But I don't really know enough about the feelings within the archaeological community. But I think these days, there would be a general perception that it's unethical. I think in that regard, within the archaeological community, there has been actually a big shift in, I wouldn't even say in perception, but simply in awareness of the fact that there is a legal background to this sort of thing, even if they don't understand it exactly, and that archaeologists have to ask themselves these questions. Now, one of the ways that this shift came about is there's been a whole lot in this regard, contestation in this regard, in relation to Israeli digs in the occupied Palestinian territory. So there has for a very long time been a very big controversy about Israeli authorized digs in the occupied West Bank, and even more so in relation to East Jerusalem. And the argument isn't necessarily that They've destroyed stuff, although there is that in the background. But simply, look, it's not your right to authorize these things. And in that regard, some people have said, well, listen, in the end, it's all good for human knowledge, and other people have said, well, no. I mean, we have to be aware of the political and legal backdrop, so that in the end, look, these days we know that the Palestinian people have a right to self-determination, which would include their right to their cultural self-determination and so on. So I think these days archaeologists have become sensitized to these things. Now, whether that means each and every one of them would consider the situation of the archaeologists we're talking about to be unethical is an interesting question, but I think we would be moving more in that direction, perhaps in a way that 30, even 20 years ago, people wouldn't really have thought too much about. They would have said, well, hang on a minute, the Russians let me do it. Aren't they the ones who enact the law? You know, I don't think archaeologists are that naive anymore. As far as international lawyers are concerned, we would say, listen, if it's unlawful, then it's unethical. It's a pretty simple equation for us.
Yeah, and I think it's now good time to think about like more broadly about the cultural heritage in the historical perspective. And let me build a kind of a small bridge. So which example you think is the closest to the Ukraine and Russia war? And what was the closest example? Because Israel and Palestine story is, I think, is not that close to what's happening in Ukraine.
Sure. So it's more complicated, yeah.
But what was like the example which you would look at more closely, like and compare it to the Ukrainian story?
I guess you could say the Turkish invasion of northern Cyprus. There has been a lot of legal stuff come out of that. So 1974, the Turks invade northern Cyprus, even though Turkey says, oh, look, we were permitted under the law to do so. It's absolutely clear they weren't. And then what has happened is that there has, first of all, been a whole lot of theft from archaeological sites, from religious sites and so on, which the Turks have not prevented. And I mean, I couldn't say necessarily that they were themselves involved in it. I don't know enough, but that a lot of the material has left and ended up in people's hands overseas. As to whether they themselves have conducted archaeological digs, it's certainly alleged to be so. Cyprus says so. Again, I don't know enough about it, but it was something that was on the agenda when this 1999 Second Protocol was enacted. And from what I know, there at the very least has been archaeological digs authorized by the authorities there in northern Cyprus, which, as far as international law was concerned, you know, would be unlawful authorization in just the same way it would be in Crimea, because in northern Cyprus they say, well, actually now, you know, we're not part of Cyprus as far as we're concerned. Actually, we're an independent state, or they call themselves an independent state. We authorized it, that's okay. But international law would say exactly as it says in Ukraine, no. It's unlawful, you're not allowed to do that. And so similar issues as came up there, you know, are coming up in Ukraine. And I think the two situations are pretty much identical from a legal point of view and from an ethical point of view as well. So there's been a lot of cases about returning material to Cyprus, and the question of, well, who do we return it to? Do we return it to the local authorities in northern Cyprus, or do we return them to the Cypriot authorities in Nicosia, even though the material came from northern Cyprus? Okay, which is a bit like the case from the Netherlands about the Scythian gold. So I think they are two very similar situations, and so some of the lessons to be learned could be drawn from the situation in northern Cyprus.
It's very interesting that you mentioned the Scythian gold case, because indeed we were thinking about it as well. So this whole case, and just to remind our listeners that this was about the gold from Crimean museums being sent to the Netherlands for an exhibition, a temporary exhibition, which was done before Russia occupied Crimea, and hence the question was where to return these artifacts. And the Dutch court decided that it is to be returned to Ukraine, to the Ukrainian-controlled territory, and they're now stored in National Museum in Kyiv. But does it tell us more broadly about global disputes kind of threatening and influencing this whole international museum and exhibition system, that they are vulnerable to these geopolitical disputes and being kind of hostages to geopolitical situations in the world?
Well, the answer to that is yeah, absolutely, for sure. I mean, we've seen it in relation to private claims against archaeological or other, let's say, artworks in exhibitions taken to the United States, for example, also to the United Kingdom. This coming out of the Second World War, people say, hang on a minute, that's our family's stuff. And a museum says, well, it's ours, we're lending it on loan. And so, in a way, the heritage becomes a hostage to this interplay of international disputes, private property disputes, and it's fascinating. There was a case recently in the US Supreme Court in this regard about I think it was an exhibition from the Prussian State Museum, which went to the United States, and then some people brought a claim against it, saying this was material of ours taken way back when. And we see a lot of it. I mean, there have actually been cases in the International Court of Justice. I mean, there was a case between, believe it or not, Liechtenstein and Germany. It's a curious case. It involved the Beneš decrees in Czechoslovakia, when the post-war government of Czechoslovakia nationalized all the German property. And that included a lot of people's private property, which had come from elsewhere, was perhaps just being stored in the Czech Republic. And this case went to the International Court of Justice. Nothing came of it in the end. We've got an interesting series of cases to do with a temple on the border of Thailand and Cambodia, where there's been more fighting recently. And way back in 1961, there was a case in the International Court of Justice about this temple. I think the Thai forces had gone into the temple and taken some stuff, saying, well, this is Thailand, we have a right to it. And the Cambodians saying, well, no, it's Cambodia. And stuck in the middle was this temple and the artifacts taken from the temple. And very, very few people know this, but actually the International Court of Justice said not only that the temple was on Cambodian territory, but the Thais had to give back the cultural property that they'd taken out of the temple. So we have, lots of these cases in which the heritage becomes a hostage. And what's interesting then is to consider at the international level, if we all have some, spiritual, metaphysical, or whatever interest in this heritage, we have the situation in which the conflict between two states is taking hostage what might spiritually be called everyone's heritage. And so everyone ought to have an interest in trying to sort the conflict out. It's yet another reason for trying to sort things out in that regard. So Yeah, it's a wonderful question, and the answer is yes, and it's happening more and more, it seems.
So far we have talked more about armed conflicts and cultural property being in the middle of it. But what about cultural property looted in times of colonization? So not through an open armed conflict, but something stored in museums worldwide, starting from Hermitage and finishing with British Museum. Can these norms we discussed today be relied upon for returning of this cultural property? Because it's still not a very common thing to do. I think the Brits and like the Germans, the Belgians, they have returned some of the treasures, but not all of them. Russians, we can not even start speaking because they haven't returned anything. But do you think it's a probability to rely on these norms for this case?
Right. Well, the interesting thing about this is that when you get to the colonial situation, and not just the colonial situation, situations, for example, of any other former empire, so for example, the Austro-Hungarian Empire and things like this, it becomes much more complicated because at the time, there were no relevant prohibitions, no international law was violated in this way, and so you can't rely on these international norms, and this is generally acknowledged to be where the road runs out. But that doesn't mean, of course, we've got no way of resolving this, because this is where the ethics come into it. Because by and large, these days, in particular, as time goes on, there is a much keener awareness that, listen, even if it wasn't unlawful, for example, to take the Parthenon marbles because the local Turkish governor, sold them and whatever, it wasn't exactly ethical either. And so that even if you can't rely on the law, politically and diplomatically, the fact that there is some sort of ethical sense of something wrong has led to the push to simply give these things back, not because they have to legally, but because they simply think it's a good thing. Now, the other thing behind this is that there's such bad publicity linked to much of these retained artifacts these days. And so a lot of the private museums and other private owners of this material have voluntarily given it back, in part because they think it's the right thing to do, but in part also because of reputational risk, reputational harm. Now, when you get to very significant pieces and very significant museums, there has been, until now, a very strong reluctance to give anything back. And this brings us to what you were saying, Julia, before about precedents. They say, oh, if we establish a precedent, okay, and they don't necessarily mean it in legal terms, but they say, look, if we do it once, why shouldn't we do it for everyone? And then our museums will be empty. These days, even those who want the material back have taken a much more subtle approach and said, listen, it's something that has to be determined on a case-by-case basis. Obviously, you're not going to give it back if it's to a place which is a war zone these days, okay? There is some argument for saying that, the British Museum or the Louvre or someone like that can at least look after it for now. Whereas if you've got a situation like Greece, or there's a new museum in Nigeria built for this sort of thing, or in Egypt, you can't really these days use the argument that, oh, we need to protect it. And the argument that, oh, our museums will be empty is becoming harder and harder to sustain. That said, very sophisticated resolutions are also being had these days involving access to the material and digitization of the material and so on. But one area in which there's been a big move to give things back is in relation to Indigenous peoples. So, for example, lots of situations in which material taken from the Australian Aboriginal people, the Indigenous Australians, has been given back not because it has to be given back, but simply because they think it's an excellent thing. And in this regard, it's been very interesting because the Australian government hasn't led the negotiations. They've allowed the Indigenous communities themselves to do it, but the Australian government has kind of opened the conversation with the museum. These days, we find it the other way around. The museum opens the conversation itself. And there's mediation in this regard rather than some sort of legal resolution. And so I always say to people, listen, I'm a lawyer so that I know the limitations of the law. And this is one area in which the law is exceptionally limited, but that doesn't mean that we can't do anything. Okay, there are many, many more tools than the law. So there's social pressure, there's a sense of ethics, there's professional standards, there's campaigning. Some stuff will be given back and others won't be, simply because some material attracts a big campaign, the Benin bronzes, the Parthenon marbles, whereas there can be other equally culturally significant material, but it simply doesn't have a spokesperson at the moment for it, which probably means that there should be more spokespersons for this material. Now, there's no reason why, of course, these strategies can't also be used in relation to situations where there is a legal obligation to give it back. So the two aren't mutually exclusive. And so they often now talk about lawfare, okay? So that you use the law for strategic purposes, but of course, not just the law. You can have campaigns linked to things. So interestingly, who did the Greeks recently, by recently, a few years ago, engage at the head of their campaign? Well, not Mr. Nobody, but Amal Clooney, okay, who's a lawyer and an international lawyer, but she wasn't being hired for her legal skills. She was being hired as, a public face, also a lawyer, but to head the campaign, which kind of had a legal gloss, but was really using her celebrity. I mean, I think she would probably concede that as well. And why not? Why not? So if you can get influential people to back either a non-legal claim or a legal claim, to get it out there in the public consciousness, then all the better. Fantastic. And I think there is this strong sense now in the general community, okay, that some things transcend national borders, okay, that everyone has an interest in these things. This used to be quite a left field idea, whereas now, sadly, with a lot of things that happen, for example, in Syria or Iraq, the destruction of Palmyra and whatever, I think there is much more now a visceral sense that these things transcend national interests. A good example, in the first Trump administration, President Trump said, we are going to destroy all of Iran's cultural sites if they don't do X, Y, Z. He announced this. They're going to fire missiles at Persepolis, etc. There was such an international outcry that, of course, he backed down. It's probably also the case that his military high command said, no, we're not. So
it's almost impossible these days to discuss anything without mentioning Donald Trump.
Exactly. You thought you were going to get away with it, but
well, yeah, I was hoping so. So I think we are almost ready to complete our call, our interview. But I'd like to give some of our listeners and viewers some practical advice. And why don't you tell us, would you bet 100 euros for the favorable decision of the Warsaw Court? What do you think? Would it like reach a decision for extradition?
It's tricky because, of course, other things go into the question of extradition. But my simple answer is yes. I think so. I mean, I'm not a betting man, but this is something I put 100 euros on for sure. Yeah.
Well, then, great. Thank you very much, Professor Akifi, for this conversation, and thank you our readers, listeners, and viewers for being with us. Yulia, thanks a lot, and probably you would also like to say something in the end.
Yes, basically you've thanked everyone except yourself, so thank you, Dima, for organizing this call and for bringing up such an important topic. That
was the easiest part. Good. Professor Akifi, any final words?
Well, all I would say is to thank you to the listeners. I hope it wasn't, I wasn't rambling too much. And I'm glad we got on to something broader than the law at the end, which, I mean, the law is great. Don't get me wrong. That's what they pay me to do. But the law is itself situated in a much deeper set of values and interests. Anyway, I would say I'm very happy to see that you're both alive, given the name of the organization. And so on that note, I hope the viewers are still alive at this point. But thank you, Dima. It was, and Yulia, it was a wonderful opportunity. And don't hesitate if you to bore you again.
Good. Then thanks and bye.
Bye. See ya.
Bye. Thank you so much.